the effective date of placement of the appellants in the senior scale selection grade without obtaining recommendation of the selection board and without taking into account past ad hoc service of the appellants under regulation 3 regulation, and thus clearly violated the UGC notification, and it cannot sustain. We therefore set aside and quash the impugn notification dated so and so and directed to restore the notification dated 10/7/2010. The UGC guideline which is involved herein, the objection the respondents are raising only one point, which has been nullified by the learned tribunal, my lord. The relevant portion of the UGC guideline, my lord, will find page 43.
Okay, not necessary if already
fact,
the same has been
yes,
set
my lord.
aside by the
Yes.
tribunal
Yes,
and that has not been challenged before this court
no,
in any writ petition
no.
or
The-
by way of an appeal
Which, my lord?
against that order of the tribunal.
Order of the tribunal has been challenged before this honorable court and dismissed.
Okay.
I have already shown to your lordships the writ court's order.
Mm.
That is at page 71,
Okay.
Annex 15.
Okay.
So
Yes.
they have implemented it, my lord, confining the relief to only do those persons. My lord, I'm just placing judgment of the Honorable Apex Court.
Mm.
That is State of Karnataka versus C. Lalita, para 29, my lord. Last page of the judgment. Service jurisprudence.
32.
Yes, my lord. 29 and 32, my lord.
Mm.
Service jurisprudence evolved by this court from time to time postulates that all persons similarly situated
Okay,
should.
Mr. Das, not necessary to read.
I'm
it.
sorry.
Okay.
Sorry. So this, my lord,
Will,
clarifies the legal position. You
Okay.
cannot do pick and choose
Mm.
in granting relief. So far as, my lord, that particular clause in the UGC notification is concerned,
Mm.
on which they are harping that the ad hoc service cannot be counted or 3F service cannot be counted. My lord, there are judgments of the Honorable Apex Court also
Mm.
after the decision of this court as well as tribunal,
Mm.
wherein the Honorable Apex Court has held that these 6 conditions you have to, my lord, read together.
Mm.
You cannot single out the clauses in the UGC notification. You cannot single out one clause and harp on that to deny cash benefit. These are, my lord, all career advancement scheme benefits,
Mm.
promotions. So that if required, my lord, I'll place subject to what they, my lord, say.
Okay.
my lord.
Mr. Gogoi, what is the stand of the department?
That cannot be counted for the case benefit person. Which is the strength of the department. I will place my case with it.
No, he has already.
My case is concerned, I'm
Regarding that particular judgment which was implemented, after that they approach the case. Case judgment is Annex 13.
Hmm.
Annex 13. WBC 3808.
second.
Second one. All in this.
My lord, the second judgment I have, second case, I haven't placed the facts before your lordships, my lord.
Then he can pick.
I'll just take 5 minutes time, the
Hmm.
second case. My lord,
Okay.
what happened in the second case, my lord? What the learned tribunal did, the learned tribunal took a diametrically, because this judgment of the previous judgment of the learned tribunal, as well as the Honorable High Court's decision was placed before the learned tribunal,
Mm.
and the learned tribunal, my lord, took a diametrically opposite stand and take a different view.
Mm. Mm.
Take a different view, saying that they are not in agreement with the order passed by the previous order passed by the tribunal.
Hmm.
Same quorum, same bench. And it distinguished and, my lord, dismissed the writ petition. Sorry, my lord, the appeal.
Mm.
So prima facie, it appears that this decision of the learned tribunal is wrong on the face of it, because the Honorable High Court has already upheld the earlier order.
Mm.
The decision of the tribunal in the earlier order that has already been upheld by the Honorable High Court. So in that view of the matter, the impugn order in the second writ petition, that is unsustainable, my lord.
Hmm.
The Honorable High Court's order was also
So
placed.
here the rejection order is being challenged.
Yes. Here also the petitioners challenged at this place, my lord. Here the petitioners challenged the order of the learned tribunal by which their prayers were rejected
Hmm.
to give similar benefit.
Hmm.
We placed the previous order of the learned tribunal,
Annexer?
annexure, my lord, lordships, page 53, annexure 11, which was the previous order, as well as the High Court order. And page 65 is the impugn order in the writ petition. Page 65, my lord will have, my lord will kindly consider second paragraph.
Hmm.
He was the author of the petition order in the earlier second paragraph of page 65.
Hmm.
A prayer was made.
Hmm. Yes.
So this prayer was made because the chairman was the author of the impugn order in the earlier appeal.
Hmm.
So even then, Milord, the chairman went on and tried to justify his own order in the administrative side by distinguishing the previous order, which has already been upheld by the High Court, Milord. And finally dismissed this appeal. So the learned tribunal completely went wrong. Milord.
Okay.
Page 66, my lord, third paragraph onwards. So this cannot be. If you are in, if you are in not, if you are, the learned tribunal is not was not in agreement with the previous order, the it could have been referred to a larger bench. But this is not the way, my lord, perhaps subject to correction, that judgment or an order of the previous bench can be distinguished, and, my lord, the claim of the petitioners or the appellants can be rejected in this manner, my lord. So on the face of it, my lord, this order is wrong. So this impugn order is challenged in this writ petition. Otherwise, the facts are identical. The same benefit was denied to these persons also. That 3-year period benefit was denied. We have relied on the previous order, and the learned tribunal, my lord, distinguished without sending the matter to the larger forum and totally ignoring the order of the High Court.
Hmm. Okay.
That is my.
Yes, Gogol.
Both cases we simultaneously lordship. Both the cases I will. In respect of lordship, 2560 lordship,
Hmm.
is 71 the Hartford civil bench order lordship, I will make kindly pay.
Page number?
Page 71 extra 15 lordship. The petition filed by the state lordship against the order dated lordship.
Mm.
It is in page 6114 lordship
Mm.
against Assam Administrative Tribunal order dated in case number 51 2010 lordship.
Mm. Yes.
May kindly read the order lordship.
Mm.
There is that lordship, the petition is directed against the page 71 lordship.
Mm.
Judgment and order dated so and so passed by the Assam Administrative Tribunal, Guwahati, in case of so and so, by which it has been held, once the basic guidelines are accepted, it will have to be accepted in toto and not a piecemeal basis. The stand of the state government is reference to the basic guideline is there. Since the notification that was issued pursuant to the basic guideline, there is no mention for counting past service rendered on ad hoc basis. That part of the basic guideline may not be applicable to the case in case the respondent who has the appellant before the tribunal lordship. Then, my lord, I have heard so and so, and I have also heard so and so lordship, learned counsel of petitioner, and there is service of the lordship. The strength of the state government may not be tenable in view of the apex court decision, that is Jagdish Prasad case lordship. In the said judgment, it has been held that this regulation cannot be applied in part, but will be applied fully merely because the state government have issued a notification in reference to the disease guidelines without mentioning a particular part of the same. It cannot be argued that the state guidelines or not part thereof is not applicable to the case of the respondent. In view of the above, there is no merit of the petition. Accordingly, that was dismissed. The basic fact is that whether the UC guidelines can be adopted partly or not.
Mm.
That part was decided. It is a admitted fact that case was already lost. It has dealt with that Jagdish Prasad case lordship. That principal's case lordship already dealt with that. Yes. There is no dispute that if this is regulations, you cannot adopt laws.
Mm.
There is no dispute. It is a settled principles of law. Court never decided whether he is entitled or he is not entitled to say. Court just says that you cannot implement the if you implement the regulations, if it should be implemented as a whole lawsuit. There is no dispute. This judgment, it is not a disputed fact, it is an admitted fact, it is a law laid down by the Honorable Appeals Court, there is no dispute. Now petitioner's case is whether they have fulfilled the UGC's required qualifications prescribed by the UGC's guidelines or not.
Mm.
If they have fulfilled the guidelines lordship, then they will come within the considered zone lordship. But you have to decide that particular fact lordship.
Mm.
UGC's guidelines, we have to follow it lordship.
Mm.
We have to apply it when they have qualified as part of UGC's guidelines lordship. A part of lordship UGC's regulations lordship
Mm.
1998, which is applicable in the petitioner's case lordship.
Mm.
So lordship में 7.2.0 lectures lordship 7.000 it's a career advancement scheme CAS scheme lordship.
Mm.
7.00 lordship.
Yes.
It's a career advancement lordship. Then my lord may kindly come to 7.2.0 lordship. Lecturer senior skill lordship.
Mm.
A lecturer will be eligible for placement in a senior skill through a procedure of selection if she or he is number one lordship completed 6 years of service after regular appointment with a relaxation of 1 year of 2 years respectively for those with MPhil and PhD. My lord may kindly mark it. They have to completed 6 years service of regular appointment lordship. That part from which that they have completed 6 years regular service, we have given it lordship. There is no dispute from that period we have given it lordship.
Mm.
The contention which court is that lordship, whether that 3 year period should be counted or not lordship.
Mm.
For that purpose, my lord may kindly come to 8.000. In respect of counting of past service. Lordship.
Mm.
So lordship may skip 8.10 up to 8.4.0, lordship may skip it. Lordship.
Mm.
My lord may in respect of TF, it will be come under 8.6.0 Lordship.
Mm.
The appointment was not ad hoc or in leave vacancy in less than 1 year duration. Ad hoc service of more than 1 year duration can be counted, provided. Lordship, their ad hoc service more than 1 year period be counted or can be counted, provided they have fulfilled the following three criteria. Lordship.
Mm.
Number one is Lordship, the ad hoc service was more than 1 year duration. There is no dispute. They have the ad hoc service more than 1 year. Lordship.
Mm.
Number two, Lordship, the incumbent was appointed on recommendation of the duly constituted selection committee. That was missing, Lordship. That criteria number B is not fulfilled by the petitioner, Lordship. They are,
How they were appointed?
they are TF
TF.
appointed, Lordship. The incumbent concerned should be appointed on the recommendation of the duly constituted selection committee, Lordship.
Mm.
That Lordship 8.6.0B, they have not fulfilled the criteria, Lordship. If we go by the prescription prescribed by the UGC, Lordship, for counting of the ad hoc service 8.6.0, Lordship, their service should be more than 1 year period, and that period should be counted, provided, Lordship, they have fulfilled the requisite qualification prescribed by the UGC, Lordship. Here, what are the criteria, Lordship?
Mm.
Number one criteria is the more than 1 year ad hoc period.
Mm.
There is no dispute. They have that period. But Lordship, the incumbent was appointed on recommendation of duly constituted selection committee, Lordship. That part is missing, Lordship.
Mm.
They have not fulfilled the criteria of 8.6.0 B, Lordship. That's why they are not come within the considered zone as per the procedure prescribed by the UGC.
Mm.
So, Lordship, the recommendation of the selection committee where we have to found, Lordship. That doesn't get found, Lordship. My lord, make silence. Kindly come to page 698, Lordship. Six nine eight, Lordship.
Yes.
It's Assam Education Service Rules 1982, Lordship.
Mm.
This rules is applicable for all the government colleges, Lordship. At the relevant point of time, Lordship, it's a government college, and this college is governed under these rules, Lordship. Class and category is, Lordship, 3.
Mm.
And Lordship, the procedure for appointment is, Lordship, Rule 5, Lordship. Method of recruitment, Rule 5, Lordship. And Lordship, Rule 6 is the direct recruitment, Lordship.
Mm.
Rule 6. If Lordship permit, I can read the Rule 6, Lordship.
Is it necessary?
Rule 6 is necessary because Lordship, the recommendation of the committee should be from the Lordship APSC, Lordship. For that purpose, we have to read it conjointly with 8.6.0B along with Lordship Rule 6, Lordship. 8.6.0 says that the incumbent was appointed on recommendation of the duly constituted selection committee, Lordship. Here, Lordship, the selection committee is the commission. Commission is the Lordship. The definition of the commission is the Assam Public Service Commission, Lordship. They are not appointed on the basis of the recommendation of the Assam Public Service Commission. They have not fulfilled the procedure prescribed in the Rule 1982 as well as Lordship, this is regulations 1998, Lordship. For counting of the ad hoc period, they have to fulfill that particular criteria, Lordship. They have not fulfilled that criteria, Lordship. So the theory appointment is there, Lordship. That's my condition.
Yes.
As the Assam Public Service Commission Limitation on Functions Regulation 1951, my lord, may get it in page 120, but I couldn't know. Only 123 page number. 123 Lordship. Assam Public Service Commission of Limitation of Functions Regulation 1951, Lordship.
Nineteen 51.
1951, Lordship.
Okay. Okay.
1951 regulations 3 Act clause.
Mm.
3 small Act clause. After the third Lordship. Here, Lordship.
Yes.
Lordship. When an appointment is to be made by direct recruitment to an inquiry post created in a service, if it is necessary in the public interest that the appointment should be made immediately and reference to the commission would cause undue delay. My lord, may kindly mark it.
Mm.
Reference to the commission would cause undue delay, provided that if the post has been sanctioned for or is likely to last for more than 4 months, the commission shall as soon as possible be consulted in all matters mentioned in the surplus 3 of the Article 320 of the Constitution, that is the direct recruitment part. So, Lordship, there is no dispute that their appointment is the exigency of the appointment, and they are appointed without the consultation of the commissions under Regulation 3. Rule says that, Lordship, it will be by the commission by direct recruitment after advertisement and recommendation, Lordship. So, Lordship, it is admitted fact that from the procedure prescribed in 1951 regulation as well as, Lordship, to 1982 rules and, Lordship, 1988 1998 UGC's regulations, Lordship, the petitioners herein are not fulfill the procedure and modalities prescribed in the Rule 8.6.0 for counting the period of ad hoc service, Lordship. As such, Lordship, they are not entitled for counting the period of ad hoc service as prescribed by the UGC, Lordship. Even, Lordship, in the rule itself, there is a specific provisions, Lordship. My lord, may kindly peruse that rule, Lordship. 1982 rules, Lordship.
In the education manual.
Education. 1982 rules, Lordship.
Page number?
Page lordship, my book, it may not be tally lordship. No? 709 lordship. This section 23 lordship. Rule 23 lordship, seniority.
Yes.
Michael got it?
Hmm.
Then Michael may directly come to page 710 lordship. Next page lordship.
Hmm.
Lower portion lordship.
Hmm.
The period of appointment under APSC limitation functions regulation before regulation to commission shall always be ignored for the purpose of determining seniority. There is a specific bar in the rule itself also. If we go by the golden principle of law set down by the Privy Council in the lordship, Nazir Ahmed case lordship, we cannot ignore the procedure and prescribe the prescription prescribed in the rules lordship. We have to act as per the procedure lordship. So lordship, rule itself, there is a specific bar for counting of the 3-year period for lordship, seniority lordship. Yes, scheme is a seniority scheme lordship. Then lordship, the judgment which was passed by the honorable tribunal lordship in Amalendu Sudori's case lordship.
Ask is good if I do it now.
Lordship, I actually did that lordship. Yeah.
Come to relevant portion of the judgment,
Lordship.
operative portion.
Page 66 onwards, lordship, I am in it. Page 66 onwards. Third paragraph, lordship, we have very strong reservation. Lordship, no problem.
Hmm.
Page 66 lordship. Before that paragraph, in respect to earlier judgment passed by the lordship.
Hmm.
We have very strong reservation for the judgment that so and so, because of which we are not inclined to entertain this application. As said,
Paragraph number?
number in page 66, lordship.
Yes.
It starts from paragraph we have strong reservation lordship.
No, page 66, it is all right. But what is the number of the paragraph?
It's a 13 lordship. Page 66 lordship. WBC lordship.
Yes. Yes, 3808. Okay. let me-
Starts from lordship, page 65. lordship.
We have a strong reservation,
Lordship,
yes.
lordship.
Uh.
We have strong reservation for the judgment dated so and so, because of which we are not inclined to entertain this application. In the said judgment, this tribunal has held that the date of appointment should be deemed to be date of appointment under regulation 3A, and the benefit of this service should be counted for the purpose of seniority to make the persons eligible for the upgradation to the senior scale and selection gate by taking into account the service rendered by the persons as on ad hoc appointment. appointed under the said regulation. In arriving the said conclusion that tribunal has quoted a ruling of apex court so and so. In this honorable Supreme Court has held that the government is not right in making a departure from the elements of the scheme recommended by the UGC for improving the higher scale of to lecturers and to divide a new mechanism. They have quoted clause 8 of the UGC's notification laying down the guidelines pertaining to the counting of past ad hoc services for conferment of senior scale selection grade to lecturers. In this, the tribunal has concluded that the lecturers fulfill the conditions laid down by this clause, and the government has no right to making a departure. The interpretation is not correct as surplus F of clause 8.6.0 as quoted in the state order of the tribunal stipulates the following conditions, Lordship. That was not discussed in this particular case, Lordship. The incumbent was appointed in the recommendation of a duly constituted selection committee. That UGC regulation 8.6.08 was already done for you. Here the words used are duly constituted selection committee. Duly constituted would mean constituted as per the rules laid down for a selection of lecturers. The rule laid down that the selection of lecturers would be done by the FPSC. That is as per Rule 6 of the 1982 rules. The duly constituted selection committee would therefore be a committee that has been constituted for the purposes by the FPSC. All the appointments have been made by the committee constituted by the government in education department. They have not been made on the basis of the recommendation made by the duly constituted selection committee. The stipulation laid down by the surplus of clause 8.6.0 of the UGC guidelines is therefore not fulfilled by this appointment. This is the correct, in my humble submission, Lordship. This is the correct findings of the Honorable Tribunal, Lordship, as per the procedure prescribed in the UGC regulations as well as the Act of 1982 laws. The second reason of our disagreement with the judgment dated so and so because the legal situation. The tribunal has quoted the ruling of the apex court, which is a general nature and is not specific to the appointment made under the regulation here. There is a ruling of the Honorable Guwahati High Court, which has dealt with the issue specifically. This is so and so, and others. In this, the High Court, Honorable High Court has specifically held the respondent petitioner will be entitled to seniority with effect from the date of his regulation / substantive appointment on so and so, not from the date of the appointment of regulation here. In a situation wherein there is a specific ruling of the Guwahati High Court that the period of service rendered on a appointee under regulation TF could not be counted for the purpose of seniority. Therefore, the apex court that held must go cannot make departure from the scheme laid down by the UGC was not correct. More so when the stipulation is laid down by the UGC was also not made. It is the correct finding as because, Lordship, there is a series of judgment of our High Court, Lordship, regarding that period cannot be counted for the seniority purpose, Lordship. And that particular judgment never placed before the Honorable at the relevant point of time. So for a moment, my Lord, I must see some trouble I think.
No,
For this purpose, Lordship may peruse the depiction 2556, Lordship. 2556. Page 61, Lordship. Earlier, administrative tribunal judgment. I will not read it. That's the point of Lordship. In this judgment, Lordship, in respect to the law laid down by our High Court, Lordship, that was never placed before the tribunal court at the time of consideration. It was never placed before the tribunal. That's why tribunal is going to get defined way, Lordship. And regarding, Lordship, the qualifications part prescribed by the UGC also not dealt by the tribunal properly in this case. They just simply quoted the provisions and they passed the order, Lordship. There is no discussions there is no eligibility marks, nothing was there. And that judgment was put to sentence before a tribunal, before the honorable court. Honorable court says that you have to fulfill the, you have to adopt the UC regulation as a total, not a peaceful manner of shift. That was an admitted fact. That was a no dispute lawsuit. Regarding eligibility part, our High Court never decided the application of civic petition where it was challenged lawsuit. Whether they are eligible or not, that part was not decided. Only Honorable Court says that this is regulation, when you have to adopt as a whole. Only that part, it is not a disputed factors. So lordship, at that point of time, when the head was decided the matter lordship, the relevant facts was not before that. The law laid down by the Honorable Guwahati High Court is not before the tribunal, and the lordship, the eligibility criteria also not decided by the tribunal. That's why they have gone in a defined way, and later period, they have realized it, and they have passed the order on the basis of the law laid down by our High Court. Now I am relying our High Court judgment regarding here. So many judgment is there, only I rely the
কি নাম? পুরো
Yes, so which paragraph is relevant?
Lordship, paragraph 9, 10, 11, 12, and 17. Just read paragraph 9 also. I point out paragraph also. Paragraph 9, 10, 11, 12, and 17. Just it is one paragraph also. Paragraph 9 also. It will appear that the instructions provided for regulation of the appointees made under regulation CA and TA of the Assam Public Service Commission Limitations and Functions Regulation 1951 within the time limit specified in the regulation itself. We have carefully examined the provisions of regulations of 1951 and we do not find any provisions enabling the authority to regularize the service of the TF appointees. The questions for applications of the executive instruction contained in the above circular to arise only when the appointments made under regulation TF are regularized in accordance with the provisions of the rules. The rules is 1982 rules. If any. But in the instant case, there being no provisions incorporated in the regulations to this effect, we are of the definite opinion that the conception of the regulation of the service of the appointees and the regulation TF is also reverse the rules. We are of the further opinion that when a person is appointed under regulation TF, he has no option but to appear before the commissions for consideration of his case for recommendations, and when the post is advertised, and in the event he is recommended for appointed, he will be entitled to all service benefits with effect from the date of such substantive appointment. The provisions contained in paragraph 10 to within bracket B has non-application in cases where ad hoc appointments are made reverse the rules under regulation TF and regularized subsequently. Therefore, the service rendered by an incumbent to the post appointed under regulation TF is not counted for the purpose of senior. Then therefore propose that an appointee under regulation It's a division bench High Court lawsuit. Then lordship, one judgment I will elect after the.
Not necessary.
So the paragraph lordship, Navin Chandra Bodole, paragraph 7 lordship. Paragraph 7. So many judgments there, I even further fixing judgment also there.
Hmm.
Lordship, before I can.
No, not necessary.
Okay. Our design lordship, is, I have license for terminal.
Hmm.
Direct recruitment is the famous that is there already lordship the chart for it, I will not rely. Direct recruitment, just the contrast the relevant paragraph.
Hmm.
So we'll have a look, my lord.
Hmm.
Assam's service manual. There is a specific rule
Hmm.
that is Assam Public Service Ad hoc Appointment Rule 1986. I was also a bit confused with regard to this term duly constituted committee, my lord. I searched, then my brother helped me. If my lord kindly take up Rule 3,
Assam Service.
Assam Public Service Ad hoc Appointment Rule 1986, page number 244.
Yes.
Lordship will kindly have Rule 3,
Hmm.
ad hoc appointment.
Hmm.
Notwithstanding anything contained in any service rule, ad hoc appointment by direct recruitment to a temporary post created under the government may be made if it is necessary in the public interest that the appointment should be made immediately and reference to the commission would cause undue delay, provided that if the post has been sanctioned for or is likely to last for more than 4 months, Commission shall, as soon as possible, be consulted for making the appointment on regular basis, as provided for in clause C of subrule 2 of these rules. All this proviso is akin to the Milord 3F proviso, Milord. This is similar to that, Milord. Now, all such appointments shall be made in accordance with the procedure herein under laid down. Where such recruitment is made, this shall be made after due advertisement for the services and post, and the selections of candidates shall be proceeded through a selection committee to be constituted as follows. This is the selection committee, Milo. This is the selection committee, and our appointments were pursuant to an advertisement and by a selection committee.
But
Because-
to support such a contention, you have no any document
It's true.
that advertisement was published and that committee was constituted.
Yes, there is no, the POV advertisement has not been annexed, or the selection committee minutes are not there.
Hmm.
But any ad hoc appointment
Hmm.
has to be by virtue of it, this selection committee has to be an advertisement. Otherwise, my lord, nobody will know that to a post of lecturer.
Mm,
And just one clarification more, the UGC regulation, my lord,
mm,
it says ad hoc service of more than 1 year duration can be counted.
mm,
It says that ad hoc service.
mm,
The ad hoc service was more than 1 year duration. The incumbent was appointed on the recommendation of a duly constituted selection. This committee is the duly constituted selection committee for ad hoc.
mm,
And we were appointed on ad hoc basis. And the incumbent was selected to a permanent in continuation to the ad hoc service without break. Later on, we were selected on regular basis.
mm,
So, if the interpretation given by the respondents is taken that this initial appointment has to be as per the recruitment rule 6, then I am a regular appointment. Then where is the question of counting of ad hoc service? If I am recruited under rule 6,
mm.
then my appointment is regular. So there is no question for UGC to formulate this scheme or this circular for counting of ad hoc service. There is no, I thought the service was ad hoc, my lord, for that period. And duly constituted committee is this committee, my lord. And the second case, the learned tribunal also recorded a finding that we were appointed by a committee, and that committee is this one. We've been appointed by following Rule 6, direct recruitment. Then, my lord, there is no question of counting of ad hoc service. That is my lord clarification before your lordships. Then this provision would not have been required. I'm not required to take the benefit of this service for indicating my thing. And after my ad hoc appointment, my case will be processed by APSC, and thereafter, after the recommendation of the APSC, I will be regularized. That is
But
the,
in your appointment letter, it has been mentioned as ad hoc appointment.
yes, it has been mentioned as ad hoc. So there is UPSC regulation is only with respect to ad hoc appointees.
Mm,
If I am ad hoc,
mm.
then I am entitled for this. So, my lord, I am extremely sorry. In the morning hours, I just failed to place this rule before your lordship.
Okay.
But I was also, my lord, having question, what is this duly constituted committee? Because I know that it was appointed, but duly constituted committee in the main recruitment rule also, there is nothing like duly constituted committee.
Mm,
Rule 6 said direct recruitment by APSC.
mm,
Doesn't speak about a committee.
mm.
So that's why it came to my mind. I asked my friend, Mr. And he clarified me this about this truth. That much only, Milot, nothing else.
That's why I refer. Assam Publication ad hoc appointment rules 1983 totally not applicable in this case, Lordship. They are appointed under the 1951 regulation 3.
No, that's true.
Totally not applicable in this case. No provision is applicable in this case.
Mm.
Regarding duly constituted selection committee, APSC is the authority as per the rules, Lordship. They have constituted committee, they have selected the candidate.
Mm.
After selection, they had recommended to the authority, according to authority, appoint members. It is the
No,
procedure.
Mr. Gogo, you see, in one of the writ petition, they have made a categorical statement
Yes,
that they have been selected by a duly constituted
Okay,
selection committee.
So, my lord, may kindly produce our additional affidavit
Mm,
by us.
mm,
Specific extent is there. They are not appointed by the duly constituted selection committee recommended by the APS. Our specific extent is there.
mm,
And no additional affidavit.
mm.
For the cases we have filed additional affidavit, my lord, may kindly produce our additional affidavit. The point raised by the petitioner is proceed and start in the additional affidavit.
Okay.
Highly obliged. Much.
I'm being Matthias, item number 8 for admission. Item 8.
So, Mr. Soma, whether you have filed a affidavit? And Mr. Devi has also not filed.
I'm declaring. I have noticed.
Assigning copy. Nothing visible.
So, you file your affidavit making the stand of the respondent clear. And Mr. Sharma? Mr. Bhuya, on the other day, you have submitted that without their affidavit, the matter cannot be adjudicated.
No, my lord, the impugn action,
Hmm.
my lord, which has been taken by the acquiring the movable and immovable property by the secondary education department, my lord.
Hmm.
Clause 9 of that notification we are challenging.
Hmm.
Now, my lord, admittedly, my lord, till this property or this institution is in a Waqf land, my lord.
Hmm.
My lordship is well aware, my lord, that once the Waqf is there, that land cannot be alienated or, my lord, the character and nature cannot be changed. So, my lord, in this Waqf institution had been, my lord, established for the purpose of establishment of a religious charitable institution, my lord. Now that institution is still existing and my lord wanted to pursue the my lord the theological subject, but that has been debarred. That is the my lord our difficulty. Even the students' enrollment and other examination, the religious part, my lord, they are disturbing, my lord, which my lord,
No, Mr.
my lord,
Bhuya,
my
you
lord,
see, when a report has been submitted by the inspector of school,
my lord.
so as per this report, the erstwhile school was taken over by the government.
My lord. My lord, what has happened in that my lord, land, there were three institutions. One is this, my lord, the petitioner before my lordship is Gwalior Nizamia Alia Madrasa. This is a purely
Hmm.
a theological non-governmental institution, my lord, run on the aid
Hmm.
and my lord, the donation by the public. Secondly, my lord, the Gwalior Senior Madrasa.
Hmm.
That senior madrasa, my lord, later on had been taken up by the government,
Hmm.
and my lord, subsequently, this madrasa is also not in existence because of the policy that all the madrasa institutions in our state will be converted into schools.
Hmm.
Accordingly, my lord, Gwalior High School had been converted. Later on, it had been amalgamated with
Hmm.
another this private respondent number so and so. After this amalgamation, my lord, just for a moment, I beg to draw my lordship's kind attention to the impugn order, my lord, is at page 57, my lord. This is the order, my lord. My lord, may kindly see at page 57, annexure 7.
Hmm.
This is an order issued on 29/3/2022 after the repealing of this, my lord, madrasa institution into schools. In pursuance of the government office memorandum communicated wide number so and so dated so and so, and subsequently as per the approval of the secondary education department government of Assam letter number dated so and so, the director of secondary education Assam is pleased to issue the order to merger of the following one high school with one high school of Hailakandi district under the Shiksha Kshetra. The detail of the schools are mentioned in Annexure A and B. This is, my lord, Gwalior High School Senior Madrasa with the IC MC High School. Now the offending clause is clause 9, my lord.
Hmm.
The movable, immovable property document records of the amalgamated school shall be vested in the name of base new school. My lord, we do not have any objection. They may, because, my lord, these are government run institutions, my lord, they can take over the movable property, the infrastructure, furniture, but the very immovable property, my lord, wherein these institutions are, my lord, this Gwalior High School and Senior Madrasa and this Nizamia Madrasa is established is the land in question is this is a Waqf land, my lord, which immovable property they can never acquire, my lord, and wherein this, my lord, Nizamia Alia Madrasa is still, my lord, surviving and the imparting the religious education of that particular area. That is our case, my lord. That instruction, I think, my lord, is required from the department also, my lord.
Okay, let them file their.
Exactly, my
affidavit.
lord. Exactly, my lord.
Heard Mr. A.R. Bhuiya, learned counsel for the petitioner. Ms. Fokon, learned junior government advocate. For the respondent number. Respondent number 6. Mr. Your name?
No, we have
Learned-
not named him as a headmaster. It is the office we have made a party, my lord. Respondent 8, my lord.
Learned counsel for the respondent number 8 and Mr. Sharma for respondent number
By name for the
4. 4. Who is 4? Okay.
They have filed their affidavit, my lord. They have
Okay.
filed their affidavit. We have responded to
That
that.
appears for the respondent number 4. Respondent number 4. Ms. Fokon submits that she has received instruction today. Accordingly, it is provided that Ms. Fokon shall file the affidavit in opposition by bringing record the said instruction by next week. In the meantime, Mr. Sharma shall also file the affidavit in opposition for the respondent number 1, 3, and 7. Rest shall list the matter after reopening.
My lord, my lord.
Reopening.
Date may
letter
kindly
produced-
be given.
The letter produced before the court today shall be marked as annexure A and be tagged, no, annexure C and be tagged to the record.
Counting item number 32.
Obliged, my lord.
May be pleases your lordship, Secretary to the Government of Assam has forwarded to the Treasury Officer, your lordship, later, your lordship. On dated
The
29/11/2025.
Amount has been sanctioned.
Yes, your lordship. Treasury is the appropriate authority, your lordship, to give the proper status of this matter, your lordship. Already letter has forwarded. Treasury here? Yes.
Yes.
No, no, resanction has not yet been done. So this letter,
In favor of his wife, your lordship, it is clearly mentioned, your
No,
lordship,
no,
or
no, no.
take the further necessary action.
for resanctioning, they have asked to return the original sanction letter.
Lordship,
You see the subject regarding resanctioning of the amount.
return of funds is needed and your lordship, loan provide certificate of current year in connection with resanctioning of an amount, your lordship. So your lordship, this to.
Mr. Soliha is present today? Soliha?
Treasury is not represented by.
Maybe.
RPN. And moreover, Treasury has not made part here.
Maybe he can coordinate with the treasury officer.
আপনাকে নিকট থেকে ফিনান্স তো সদায় পাঠিব না বিল এমাউন্ট তেওঁলোকৰ তাত ৰল কৰি forward funds.
Soliha, can you obtain instruction from the treasury officer of Golpara Treasury regarding the status of this letter and whether he has returned?
My lord, I am from my lord Dhuri, but the treasury officer is Golpara mentioned here, my lord.
Hmm.
Petitioner is from Dhuri, my lord.
Now, yes, up to the.
So if they sent it to the wrong treasury, how can, I can call out Lordship and find out. Lordship, if the wrong treasury of it has been sent to the wrong treasury officer.
Okay, whether the earlier sanction order is part of the record.
Yes, yes, my lord. My lord, kindly see page 31, my lord.
Yes, page 29 also it is Dhuburi Treasury. Hmm?
Thereafter, my lord, advice slip also issued, my lord, that is page 32. Dhubri Treasury, my lord.
In connection with district Dhubri in connection with number so and so dated 4971/2025. It was clearly mentioned district Dhubri. It might obtaining instruction, your lordship.
No, the letter you have produced before this court today is of 29/11/2025. Here, the treasury officer, it is addressed to the treasury officer, Gwalpara Treasury.
Lordship, I can write every instruction.
No, you will not get the instruction. How you will get the instruction? It has not been sent to Gwalpara. No, you verbally confirm with the secretary where they have sent this letter.
By Thursday, I can get the instruction from Bond
Let
Treasury.
me obtain instruction, your lordship, if it does not, able to, your lordship. In the meantime, your lordship, your lordship, I will go down regarding the treasury officer, this Gwalpara treasury, they have referred. And let him obtain instruction, and I will also obtain instruction.
Lordship, if it's on Thursday, on
Yes,
Thursday, I will get a clarification from the board, because Lordship, sometimes if the person has earlier drawn us some, Lordship, there are certain technicalities, Lordship. So I just want to confirm if, on what basis they have sent it, and whether any record is available with the treasury of the board. Lordship, this is on Thursday.
No, may not be because the earlier sanction order was forwarded to the treasury officer, Dhubri.
Yes.
Dhubri, my lord.
Mm. So this is a small amount. The petitioner is moving from here and there.
Yes, my lord. My lord, suffering. Since my
Heard
lord,
Mr.
2020, my
Hussain,
lord.
learned counsel for the petitioner. Also heard Miss Das, learned counsel for the state respondent number 1, 2, and 3. Mr. S.K. Mehdi for the respondent number 5. And Mr. Soliha for respondent number 6. While the matter was taken up at 2 o'clock, Ms. P. Das, learned counsel, pursuant to the direction issued by this court, obtained one instruction and produced a letter dated 29/11/2025, written by the secretary to the Government of Assam to the treasury officer, Gwalpara Treasury, for returning the original advice slip and non-dual certificate of current year in connection with re-sanctioning of the amount of rupees 4,37,829 rupees towards medical reimbursement of the late husband of the petitioner. But it appears that the petitioner belongs to Dhubri district and the husband of the petitioner also retired from SPHS school, which is situated in the district of Dhubri. But this letter was addressed to the treasury officer, Gwalpara Treasury. Accordingly, it is provided that Mr. Soliha, learned standing counsel for the respondent number 6, shall obtain respondent number 6, and also Ms. P. Das shall obtain necessary instruction in respect of the status of the letter dated 29/11/2025, and as to whether this was properly addressed to the treasury officer, Gwalpara Treasury, or not. List on Friday.
And deeply. Your lordship.
No, no, no.
My lord, by
no.
this week,
By this week, your lordship, by this week, Wednesday.
Wednesday, tomorrow.
it can be on
Thursday,
Thursday, my lord.
Thursday, no.
Monday, your lordship.
Okay, Monday.
And deeply over.
Number 15.
Pardon? Hmm. What to do then? After some time, let him. After some time. But we don't have mass matter. It will be winding up shortly.
Item number 20 for hearing. There is this case from the lordship has passed earlier order. One is of, one is of 29/4/2025. It is an instruction that both the parties immediately settle and to file a review.
Hmm.
That we have filed a review on 29/5/2025. We agreed that 13,000 per month we are ready to pay. But they have not filed any AVDB. On 9/9/2025, the lordship passed another order. That order, the last two lines, my lord, division course of deliberation, it is submitted at the part that the parties have agreed to settle the matter and they will be filing an AVDB for next year. They have not filed an AVDB, my lord. And I am in trouble because there is an interim order staying the withdrawal of this suspended application will be, my lord.
Hmm.
And I am a billing person. I am in trouble, my lord. There in this case has not been disposed of as of today. That is pending. If they are, my lord, agreed, they should file a bid, they should see.
Mr. Bhuya, what is your instruction?
My lord, on the last occasion, my lord, I have summoned this minor, my lord. She was at that relevant period of time minor. Now she is a major, can take her own decision, my lord.
Hmm.
My lord, the 13,000 I have requested her to accept to finish the matter. But my lord, she says that she had to study as well as she is now in a hostel, my lord. So therefore, the burden is within this 13,000 is it will be difficult to pursue her studies. So can it be enhanced, my lord, a little bit, my lord, than
Where,
she will be
where she has been pursuing
my
studies?
lord, this is pursuing in, my lord, in a degree course, my lord. Sapor College, my lord.
Sapor.
In Sapor, it is just, my lord, going while we pass.
Yes, yes.
That's
Sapor.
that. Sapor, and she is originally resident of Goalpara, my lord.
In between Bongaigaon and
Yes, sir.
Bilatipara.
Just the after crossing this area, my lord.
Bongaigaon and Bilatipara.
Yes, yes, within this range, my lord.
My lord, is undergoing the degree course in Vilashivara College by staying in her sister's house. The petition number petition number
Chalo thak.
2.
No,
No, my lord, that is.
Mr. Sikdar, what is the amount that you are receiving?
My lord, at this stage, I cannot say when the money is stopped, my lord.
No, earlier.
My lord, this is a scheme under the compassionate family pension, my lord.
Hmm.
Under that scheme, before the date of retirement, my lord, the regular salary my mother received, my lord.
Hmm.
From that salary, not a single pie had been paid to me for my expenses, my lord.
Hmm.
Later on, my lord, when my father, before the my lord retirement, he succumbed, my lord, he died.
Hmm.
Now it will be governed by the regular pension law, my lord. That is the pension rule of 1969. My lord, therefore, if the amount can be enhanced in the earlier part, DCRG and everything benefit, my lord, as per my instruction is been already been
Withdrawn.
taken up by my mother, my lord. Not a single paisa had been paid. So that's why, my lord, at least a little amount can be paid and can be enhanced to me, my lord. We also insisted her that they should end, my lord, as they have agreed for
Mr.
some amount.
Sikdar, what is the amount you are offering to her?
My lord,
13,000, my lord.
13,000.
13,000, my lord, the petition,
Yes, sir.
my lord, my client was Welcome. On our request, he has agreed to enhance up to 30.
He is receiving
And,
60,000 at this
see the
moment.
mother. There are other children, other son daughters, they are to look upon the entire family's burden is upon her, upon the. upon my
Our
part.
family.
And my lord, there is a policy, insurance policy in her name, I have opened. And of-
No, maybe,
My lord, see, he has no other liability, my lord. He is living singly. There is no minor to look after, only myself, my lord. That is our instruction, my lord. That instruction is not correct.
Mr. Sikdar, can it be enhanced to 15,000?
My lord, I respect my lord. Maybe you want 14,000.
No.
Not a case of bargaining. my lord.
That we are saying from our. own account,
No, no, no,
without
no.
Having instruction from the client,
No.
then we have to obtain instruction.
Court can give a direction.
Only 1,000. If you were receiving 60,000, you can pay 15,000 to her. And Mr. Sikdar, you see, the amount will be increasing gradually, na? Your amount, because of the DA.
No, my lord, pension, the pension.
Yes.
You can say.
Pension
Mr. Barua,
Yes.
they said DA will be increased in 2
Yes,
times.
yes.
This pension is being provided by director of pension
Hmm.
by us.
Hmm.
But,
No, maybe, even then.
Pension increase, my lord. Increase. My
pension
mother,
will increase
my
because of
mother is.
increasing the DA by the government.
Exactly, my lord, exactly. My mother is a teacher, my lord, her pension also get enhanced time to time, my lord.
Hmm.
But, but only 10 minutes, my lord, let us have a talk with the client for.
You tell them that 15,000 is final.
Then
Okay.
their lordship- then their lordship
My lord
proceed
can
to pass
dispose
over.
of, my lord. My lord can dispose of, my
Lordship
lord.
No,
By
whether
directly.
We'll say that.
filing of
affidavit.
Yes,
affidavit.
on amicable settlement among the parties, my lord. And my lord, the arrear which is pending, my lord, that should also be paid the accurate amount to us, my lord. That may be recorded accordingly, my lord.
Okay,
My lord,
we'll pass order.
my lord.
Mr. Sikdar, you see
But-
the
I will tell.
arrear amount has also been paid to her.
Yes, yes.
Arrear amount.
Arrear of
Yeah.
the pension. Obliged, highly obliged.
21.
Last several days, he was directed to.
My lord, my lord. So some instruction we are awaiting, my lord, by compiling all the documents, my lord, we have filed our rejoinder affidavit. my lord.
To me at 10:30.
Okay. Heard Mr. A.R. Bhuya, learned counsel for the petitioner, Mr. P. Nayok, learned standing counsel for SSA. Mr. Nayok submits that the copy of rejoinder affidavit is furnished to him today morning. Today morning, and he has not gone through the same, and he tries for listing the matter after vacation.
My lord. After. My lord, can an attempt be made before the vacation? I am salary less.
Say a lot of cases are fixed. Cases are fixed.
10th of January, my lord.
Recessal is the matter in the first week of January 2025.
Not
That-
the first week, Lord, okay? First week, from 19 to 22. Immediately. First week.
19 to 22.
Second week.
20 January.
Obliged.
Item 22.
Yes, we will. Definitely.
Yes, Mr. Das?
Yes, my lord, but order dated 19/8,
Hmm.
your lordships raised the question with regard to maintainability of the repetition
Yes,
from an order passed by the civil court
tribunal, yes,
tribunal.
yes.
Lord, in that event, my lord, your lordship wanted me to satisfy.
Hmm.
My humble submission would be that as a educational tribunal, the learned civil code discharge a quasi judicial function.
Hmm.
And because of that, my lord, it's not a order passed by civil court. Although the presiding officer is a judicial officer, but it's performs a quasi judicial function. And in that view of the matter, the repetition under 226 is maintainable.
Hmm.
And to that effect, my lord, one judgment, in fact, one Supreme Court judgment and one Delhi High Court judgment.
Hmm.
I will kindly have a look, my lord. I'll just indicate the
Is
paragraph.
it directly concerned with the issue involved in this case?
One is with regard to educational tribunal.
Hmm.
An employee was dismissed from service.
Hmm.
Then he approached the educational tribunal. Then, High Court under Article 226.
Hmm.
Para 9, my lord, will kindly have a look.
This Supreme Court decision.
Yes, my lord. 2019, 2016, 9 STC 263. Nine. There is another issue of defending its own order, but in para 9, one in 3 conspicuous lines,
No, there is no dispute regarding this 227.
226 also, Lord,
Hmm.
because
But this
in
has
the Delhi High
exactly
Court,
not gone through by the Supreme Court in this case.
in the Delhi High Court judgment,
Hmm.
my lord can have a look at para 9.2, 13.1 and 14.
So, the issue was raised by this court on the ground that several other writ petitions are pending before this court.
Another,
And,
there is another petition.
No,
Yes,
several
yes,
others.
in this issue, yes, correct, my lord.
Yes,
Yes,
against the order of the Educational Tribunal.
yes. It's like, my lord, then like Assam Administrative Tribunal is there.
Hmm.
Against the order passed by the Assam Administrative Tribunal, we proceed. Then Central Administrative Tribunal also there. But by virtue of L. Chandra Kumar,
Hmm.
the Central Administrative Tribunal are assailed as a writ petition under Article 236.
Hmm.
But it comes before the division bench because of the judgment rendered by L. Chandra Kumar
Hmm.
by the Honorable Apex Court,
Hmm.
1990 and 1990.
Hmm.
So there a clear picture has been given. And the tribunal, the civil judge, civil court, although is presided over by a judicial officer, but the ultimate function is of a tribunal. The learned presiding officer, acts as a acts a quasi-judicial function, discharge a quasi-judicial
No,
function.
there is no doubt about
If
it.
if he discharge a quasi-judicial function, then the Delhi High Court says that the read under 226 is maintainable.
Hmm. Which is the relevant paragraph? Yeah.
Para 9.2, 13.1 and 14 of the Delhi High Court, my lord.
Hmm.
Well, the issue is a bit when some deliberation is required. If for any moment I fail to satisfy your lordships on this, my lordship will give me some time, 1 or 2 days, my lord. Some difficulty was there 2 days back, my lord. So that's why I wanted to search more. But the issue is very sensitive because it will have a bearing in the other petitions
Yes,
also.
yes. Yes. And unfortunately, in the act, nothing has been
Nothing.
provided.
There is nothing, only one office memorandum is there,
Hmm.
that educational tribunal by the district judges.
Mhm.
But Delhi High Court, my lord, gives some picture.
Hmm. Maybe there are some actor rules in that state. Anyway,
In that even, may I just 2 days time, any date in the next week, my lord.
Okay.
In Saturday, Sunday, I'll do more work, my lord.
Mhm. Heard Mr. Das, learned counsel for the petitioner, Mr. Chakraborty, learned counsel for the respondent number 4, Ms. P. Das for respondent number.
Second.
L. Chandra Kumar to Angul.
This one is one.
1, 2, and 3. Mr. Das, learned counsel for the petitioner submits that he may be granted 2 more days to make research in respect of.
Right now, we're
So that is not required, ma'am. It is between the suspended delinquent and the school management. Now, this say it was fixed for hearing, wherein on the last occasion, my learned friend instead of satisfying the honorable court as regards maintainability of the writ petition, has come up with an affidavit whereby he has questioned the maintainability of the proceeding before the educational tribunal, to which I have responded also. So my only difficulty, my lord, is my client has been placed under suspension on 2/9/2007/2021. And thereafter, she was dismissed on 28/7/2021 in 4 years. Since she has been dismissed from service. We were relegated to the London Educational Tribunal pursuant to an order passed by this honorable court in the earlier round of litigation at the instance of my opponents out here. Now, thereafter, we approached the Educational Tribunal. We are the appellants before the Educational Tribunal. We have sought to bring certain documents on record before the Educational Tribunal to which they have objection. Now, there was an order passed in our favor again, but they have come up in this petition in the year 2023, and there is a stay in regard to the operation of that particular order. Now, if that particular order goes mal, then I am literally, there is nothing left in the appeal. I cannot establish my case in the appeal. Now, that order is the reason, the stay of operation of that order has culminated in a situation where that the matter before the Educational Tribunal assailing my order of dismissal, that has not proceeded any further. So it is from 2021, your lordship kindly considers, and I have been dismissed. And the matter before the Educational Tribunal is pending since 2023. So my humble claim would be here, there is no necessity of any affidavit by the state.
No, here the order passed by the tribunal is being assailed.
And moreover, your lordship responded 1, 2, and 3 by secondary education, and here the matter is that the smart-
No, you may file your affidavit. Who prevents you?
Pardon.
Who prevents you in filing your response? But we will not grant you time till perpetuity. We will grant 2 days time. In the meantime, you come prepared and argue the matter.
My lord,
কি করলো না?
my lord, I'm grateful, my lord.
As to whether against the order passed by Educational Tribunal, the petition under Article 226/227 will lie or not. Fair allowed recessal is the matter on Friday. Or sorry, on
Any
Monday.
date in the next week, my lord. Monday, Tuesday also do, my lord.
Okay,
I think
Tuesday.
will be better, my lord.
Tuesday, okay, Tuesday.
Tuesday,
Okay.
Okay.
but I'm grateful, my lord.
Item 23.
So sometimes it will happen.
So Bora, you say on 6/11/2025, you have been granted 1 week time to file the affidavit. Then on your pair, the matter was listed on 27/11/2025, but on that day, the same was not listed. But why your affidavit is not ready? But I have seen Mr. Khatonia today in the court.
He informed the petitioner also that he will not.
No, secondary education she can represent,
He only.
but when it will be filed? After? Mr. Soikia?
after the beautification. Let him file the affidavit.
Heard, Mr. I.A. Soike, learned counsel for the petitioner. Miss P does for the respondent number.
Better, my lord, replace to reversion of the petitioner. In the meantime, he has retired as fixer. As fixer, my lord. So, my lord, basically, my lord, the purpose has already become, my lord, infructuous, but the order of reversion is required to be, my lord, set aside because of, my lord, payment of pension. As he has retired already, my lord. So, my lord, what should we take a
Person is already retired.
already retired.
Okay. And Miss D. Deca, learned counsel for the respondent number 4. Mr. P. Bora, learned counsel appearing on behalf of Mr. N.J. Khatonia, submits that. Okay, okay. Ms. Das submits that she may be granted some time to file the affidavit in opposition. We are allowed to list the matter on 22nd of January. It is provided that if the state respondent fails to file their affidavit in opposition, the court will proceed to hear and dispose of this petition without their affidavit.
Publish, my lord.
Matters 24 and 25.
Can it be after the vacation? The joint
Yes.
prayer. It's a joint prayer. Can it be after the vacation? Sir? Today they have,
You are referring for?
my lord, for the respondents, my lord.
You are not ready today. Who?
Is the
Ibrahim.
leg. We can have it after, my lord, the EU vacation. Any hearing there? Or-
Okay, as agreed by learned advocates of both the parties, recessor leaves the matter on
28 January.
28.
Well, interim order passed. earlier.
Okay, interim order passed, they shall continue.
Oblige, deeply oblige, oblige.
Item 26.
Yeah, Pinto. Lordship, advertisement is in page my lord 20, my lord. As per this advertisement, my lord, the petitioner applied for the post assistant teacher LP school, my lord. It's online application is my lord page 24, my lord. He submitted online application on 22/3/2023, my lord. At the time of application, my lord, he submitted, my lord, two mark sheet, my lord. Page, my lord, 16 and 17, my lord. And after application of the document, my lord, the respondent accepted, my lord, mark sheet in page number 16, my lord. And page number 17 was not considered, my lord. And
Mr. Bora, whether the process is still going on or it is completed? Completed.
Requirement marks, not the original one. That is why it is marked for considered as per page 16. It is not considered the original mark. So unless it is page 16 is a requirement. Second one is also on the page appears on the.
National Institute of Open Schooling, my lord.
Because it is original.
So if the process is already completed, then whether any stay order is operational? No. Whether there was any direction to keep any post vacant for the petitioner? No.
Lordship, first order may be taken, my lord. Order dated 24/5/2023, my lord.
Hmm.
And then this is all, huh?
Hmm.
Here, my lord, the last paragraph, my lord. Since it is submitted that more vacancies are likely to arise in the event of the writ petitioner is successful, this court would consider passing appropriate order for his appointment.
No, the question is whether such vacancies arises.
It is their submission, my lord.
We publish in the newspaper, we should advertisement. Other thing is that this case is not maintained because he should have submitted the original mark sheet at the initial stage. He has submitted both the kind of recommendation.
Original mark sheet, original mark sheet and betterment mark sheet, mane both the
No,
mark sheet are same, my lord.
What was stated in the advertisement regarding the documents? So there is provision for any other mark sheet and certificate of higher education.
It's not higher. Yes, he says as LC. Betterment marks. He has uploaded first betterment marks, second betterment marks. Original one.
Original, my lord, I shows at the time of verification, my lord. That is not required in the online, my lord. That is not required for
No,
original.
now
mark sheet.
the question is whether such vacancies are available or not.
That instruction may be.
No, you first ascertain, because it was your submission before the court. Heard, Mr.
HL Ashok.
It's a law school learned counsel for the petitioner. And Mr. P.K. Bora, learned standing counsel for the respondent in elementary education department. After hearing learned counsel for both the parties, it is provided that Mr. Bora shall obtain instruction in view of the order dated 24/5/2023 as to whether more vacancies has arisen in the meantime, as Mr. Bora, learned counsel, standing counsel for the respondent, submitted that the process initiated by the advertisement dated
11 to 2023, my lord.
Page number
Page number 20, my lord. 20.
by advertisement dated 11th of February 2023 has already been completed. This is the matter on Tuesday, next Tuesday. No. If vacancies are not available, then we have to dismiss this petition.
Most of it.
Before petition. No, next or Tuesday, 16.
Item number 15, timing matter.
Right, Vijay. I'm sorry, Milord, I was on legs. Milord, what had happened in this case? District level scrutiny committee, Milord, has shown the respondent, private respondent as an excess teacher in the science stream for provincialization. So that is how, Milord, they filed a suit before the trial court, Milord. Trial court has decreed the suit,
Tribunal.
and that is how we are before your lordship. Now, Milord, my objections are twofold, Milord, without going to the merits.
You are for
I am for the writ petitioner, Milord.
writ petitioner.
Actually, my name was recommended by the district level selection committee.
Two names.
Okay.
Two names.
My name is not.
Because he was shown as excess teacher.
Five.
Five. Yes. Now, Milord, I am raising two preliminary issue, Milord. Please have the code, Milord. এখন দিব না। Milord will kindly come to page number. Please come to section 14 at page 123, Milord.
Yes. Appellate authority.
Yes. State level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee, and state government in the concerned administrative department shall be the appellate authority against the recommendation of the state level scrutiny committee. So since they were aggrieved by the order of the district level scrutiny committee, so under the statute, Milord, there is an appeal provided, which they have not availed.
Before the state level committee.
Yes, Milord. That is my first objection. Second, Milord, Raptip will kindly come to section 90. No suit proceedings or other legal proceedings shall lie for anything done in good faith under this act, except with the previous sanction of the state government. So, Milord, it is something like 80, section 80 CPC, Milord. If you have to file a suit against the state, you have to take sanction from the government. So, Milord, neither they filed any appeal before the state level scrutiny committee, and while approaching the Milord Education Tribunal also, they have not taken the sanction of the previous sanction, and the expression used is previous sanction. If, Milord, the word previous would not have been there, even post facto sanction also could have been done. But when the expression used is previous permission or previous sanction, that is mandatory. So in the absence of that, Milord, my humble submission is suit was not maintainable.
But whether that issue was raised before
Yes.
the tribunal?
Yes.
And
Yes,
how the
yes.
tribunal has dealt with the same?
No. Milord, order of the tribunal is at 77. আমি বলছি না আমার কনটেনশন আছে না If your lordships will kindly come to page number 54, my lord. Our object written statement before the tribunal. One. My lord will kindly come to my lord, page 54.
In,
Page 54, my lord.
okay, okay.
This was
Annexure-
our
Annexure
written
five, okay.
It was our written statement filed
Mm.
before the tribunal. Before presenting his defense as to the averment so made by the plaintiff, respondent respectfully states that the petitioner has got no locus standi to hesitate them before his honorable tribunal, in view of which the suit is not maintained with the present facts and circumstances, as well as hence the same is liable to. That about the cause of action and the relief as sought for in the suit is arising out of the Assam Venture Educational Institution Act as amended in Penso. The said act has already been struck down by the division bench of the Honorable Guwahati High Court. Therefore, cause of action is no more in force. Moreover, as per Assam Education Provincialization Penso Act has already been enacted for the process of provincial or existing teachers and non-teaching staff, including the left out candidate, have already been ensured and not yet finalized. In a view of the matter, present suit in its present form is premature and as such not maintainable. India has no cause of action under the Act of Spencer has arisen. As such, the present suit is liable to be dismissed. Now, there is one more aspect, my lord. I'm sorry, I must have pointed out. My lord, lordship knows the recommendation in our favor was, my lord, under the 2011 Act.
That has been struck down.
Yes. And now, most importantly, my lord, if your lordship will kindly see the savings clause.
But that saving clause creates a lot of problems.
No, my lord, nothing has been said. Other than appointment, nothing has been said. That is why.
No. Some other sentences are also there.
No, my lord, I'll just show, my lord.
Hmm.
I distinctly remember arguing this case, my lord, on another occasion. If your lordship would kindly have the Act of 2017, my lord. One page are there. I think
Section
para 24.
24.
Yes. Kindly see, my lord. Assam Venture Educational Institution Act of 2011 and various amendments, which have been struck down by the Honorable Guwahati High Court by order dated 23/9/16 in WPC number 24, and all rules, orders, notification issued thereunder shall stand repealed. However, all teachers whose services were provincialized prior to 23/9/16 shall continue and their cases shall be reviewed as per the eligibility norms set forth for the provincialization under this Act. What was saved, that was also with a rider. That means those whose services were provincialized under the Act of 2011, those will be reviewed under the provisions of the 17 Act.
But the question is, the situation in the before struck down of the Act and now are different, and the eligibility criteria are also different.
Exactly. Therefore I am saying, my lord, there was no cause of action because there was a cause of action in my favor. There was a district level scrutiny committee recommendation in my favor. That did not see the light of the day because that was interfered at their instance. Now today, my lord, neither he nor I can claim anything unless our cases are considered under 2017 Act. So what is there in this case? That's why I said, my lord, I should have pointed out this aspect at the very beginning. Because, my lord, after repealing of, my lord, I'm sorry to say, this is not how an act is repealed, my lord. And this act, this judgment was on a concession. I do not know, my lord, what is this? End of the day, if a legislation has to be struck down as ultra virus, the court has to record a finding. But it was done on concession. Then, my lord, can you see the repealing clause? What has been repealed? If the recommendation of the, my lord, district level scrutiny committee would have been saved, in which case there would have been a surviving cause of action. But that recommendation in my favor is also not there. Tomorrow, if, my lord, that recommendation is sought to be acted upon, somebody can challenge my recommendation also saying that as if that act is no longer there, therefore your actions are gone. Only those cases where recommendations were acted upon and appointments were made, those were saved with a rider that those will be reviewed to find out whether, as your lordship has pointed out, whether you have the educational qualification or other requirement envisaged under the 17 Act there or not. So that way, my lord, what survives in this litigation?
No, another problem is that some writ petitions were allowed under the Act 2011.
Yes.
Now directions were issued for provincialization of service.
Yes.
Government has
No,
filed
that
review
is-
petition.
That will be in
we
an
are not-
individual, my lord, in an individual case.
Hmm.
Normally, my lord, what happens? Normally, when a statute is repealed, as we often find in different statutes, my lord, it is always said that actions which have been taken are saved. Normally. Now, here, what was saved? Only the orders where those recommendations which are acted. In other words, if there was any provincialization order, those were saved. Supposing in some statute says pending provisions will also be saved. Now, if it would have been the intention of the legislature to save the pending recommendations, then it would have been expressly said. It has not been said. Of course, that is one of the arguments, my lord. But my first argument is this suit itself is not maintainable because you have not taken the sanction. Number two, against the order of the district level scrutiny committee, you should have preferred in anyway, my lord. That is a point which your lordship may like to agree, may not agree regarding that, my lord. Alternative remedy part. But regarding sanction part, my lord, it is a open and shut case.
Mandatory provision.
Yes. So therefore, the judgment has to go. But I feel even I don't have any right, though even my name was recommended. Subject to, my lord, what will transpire, I don't know. Because those actions are not saved. As if, my lord, that action was not even there.
What will happen then?
My lord, I have a feeling perhaps I cannot enforce this. I have a feeling, I do not know if it's wrong, I may be correct.
No.
Because if we give a strict meaning to this, my lord, savings clause of 24, nothing has been saved. We can't even apply principles
No,
of
no,
the general,
you
section
see,
6 of the General Clauses Act also.
Yes.
We can't apply because there is a provision here. A critical case.
No, there are a lot of writ petition involving this issue.
Yes, my lord. My humble submission is, my lord, going by the language of section 24, I don't think anything else has been saved. When the legislature has not done something, my lord, we cannot impute anything. Duty of the court is to give a meaning to this section 24.
Yes.
But in any case, my lord, they have to overcome the hurdle of section 19. On merit, I am not even troubling your lordship.
Okay. Yes.
I am for the responsible side. It's not a single allegation against either by the petitioner and the responsible against the criminal side. Because lordship, either way, lordship, I am the second signal post and lordship, my friend is claiming that he should be the high service in province that's called a service combination and the rest separate regulation. And lordship, the other very on the basis of seniority. Now lordship, my name is recommended in 2013. There are 10 posts allotted in Bangla, Bandamani High Secondary High School. All the eight posts were provincialized with effect from 1 March 2013. Only these two existing high school posts have been elected on. Only because of the long pending litigation. Lordship, the senior income has gone into the tribunal lordship. And lordship tribunal has also given the verdict lordship. Seniority has been decided. In fact, there is no dispute with regard to seniority. And lordship, other than lordship, I have placed the judgment. Exactly identical is that decided by the honorable court on the same issue. Lordship, can this see my IDC 127 written argument on behalf of the applicant does not proceed?
In I. Yes.
Open the public also.
Yes.
So, look, I highlighted the by market.
Mm.
Assam Pension Education Institution Provincial of Services Act 11 clearly provides that provincialization of services are to be carried out on the basis of seniority principles, and there is no provision in the act that is criteria of combination of subsidy of services. And this was decided on after start downwards, 5/5/2016. And another judgment was the next page, Article Roma. Next page. Same issue also came up before the consideration.
But these decisions were prior to,
2011 was struck down in the case of Convent Fund Negotiation.
Mm. Okay. Yes, Mr. Das,
Yes.
you have for respondent number?
Senior most,
You have for respondent number?
I'm for respondent number 5.
No, 5.
You are respondent number 6. The name, the district scrutiny committee has recommended the name of Ram Ali, the petitioner, and me.
Mm.
And that was in 2013. Only because of the pending litigation lawsuit, my service has not been provided. And there is nothing on record lawsuit, there is not a single allegation against me. I have made a petition and then from your 6 also. Right.
Yes.
Very outside, you stating the submission of made by the petitioner is difficult, then the petitioner doesn't want to continue with the petition. Because in that event, the petition can be withdrawn and the order of the learned court below will be upheld. The reason is that the headmaster of the school has filed an affidavit saying that from 2022 onwards, the petitioner is no longer in the school.
Mm.
He is not attending the school.
Mm.
So he is not very keen to get his provincialized because from 22 onwards, there is a specific affidavit filed by the, I'll just place, headmaster of the school. Yes. Page 100.
In the main petition.
There is an affidavit in opposition filed by the headmaster, that is respondent number 4.
Page number 116. Yes.
So he is no longer attending the school since 27/5/2022.
Mm.
If that be so, he is not willing to, because he is reluctant for his provincialization. That's why the petitioner made the submission that perhaps he will also be not entitled in view of the saving clause of the 2017 Act. So that's why that submission has fallen. Background. Now, if I place the facts before your lordships, the petitioner was initially appointed on 25/2006.
Mm.
And the respondent number was appointed on 12/9/1996.
Mm.
10 years. Now, the petitioner was erroneously recommended petitioner and respondent number 6. Although I was senior most,
it's an admitted factual question that I joined in the year 1996. For the educational tribunal, all the witnesses had deposed that I joined on 12/9/1996. There is no iota. In the instant proceeding, also the headmaster filed an affidavit saying that I joined on 12/9/1996. So, but for some reason, while the list was sent, my name was not there. All, as has been said by my learned senior, all were provincialized except these two teachers. Instead, my name, the name of the petitioner was incorporated. I submitted a representation to the director. Director sent a letter for correction, and nothing was done. In that, when I approached this honorable court by filing a writ petition. Now, this writ petition was filed in the year 2013. That is WPC number 2913/2013.
Yes. Page number?
Page number 160. In my affidavit.
Yes, order dated 26/5/2017.
26/2017.
Yes.
After discussing everything, page 163, I'll already kindly done.
Yes.
Since the services of the petitioner as the register number 5 and 6 have not been provincialized yet, this court is of the view that the seniority dispute of the petitioner and the respondent number 5 and 6 should be considered by the concerned educational tribunal. It is worth mentioning that the state government in the education department, after the state 2011 act was declared unconstitutional by this court, has been a new act for such provincialization, namely assigning provincialization service of teachers and reorganization educational institution Act 2017 into force with effect from 11/4/2017 and subsequent to of section 19. The state act also specified about such education tribunal. Considering all this, the petitioner is directed to approach the education tribunal to determine the issue of seniority between him and the respondent of 5 and 6 for provincialized to serve as science section in the school in question, which has already been provincialized so and so issued by the last page is missing. But the fact of the matter is that both the parties were relegated to the learned tribunal for determination of the issue of seniority. The learned tribunal, after I'll provide the last page. Provide the last. Learned tribunal, after discussing everything, by instance, order your lordship. Order of the tribunal filed in fine is 78 of the petition. Why I am pointing this, Lord? If it is the proceeding was instituted before the tribunal pursuant to direction of the honorable court. When the question of restriction under 19. They have taken a plea in the repetition that 19(1) of the act prior sanction is required.
No. The court has never directed that any of the provisions should not be complied with while
No.
filing the.
That has not been said.
Hmm.
But once there is a direction by this honorable court relegating the petitioner to the petitioner tribunal for determination of the issue of seniority for the purpose of provincial election. In my humble submission, the question of previous section of the government doesn't arise because it was pursuing the direction of the court.
No, maybe, but provision is there.
Provision is there. But
Yes.
even if, despite that provision be there is a direction. The direction of the honorable court in my submission is on a higher footing. Provision is there, but despite this provision, this honorable court directed, it was also a party.
No. That argument cannot be accepted.
Yes.
Cannot be. You have to file the suit in accordance with law, as provided under the Act. Court never says that, you file, go and
Bypass
file the suit
19(1).
without giving the notice and sanction or taking obtaining sanction. That cannot be.
Facts are like that only, that there was a direction by this court and pursuant to that direction, the petitioner, the respondent number 5 had approved the educational tribunal for determination of the issue of seniority.
If there is a requirement of obtaining sanction or giving notice, you have to comply with the same. So how the tribunal has dealt with that issue?
The tribunal, take your lordship's page 78. Issues were framed. The issues which were framed page 84.
Suit is maintainable if in present form. Yeah? No?
Yes.
The issue there, para 10. Whether the suit is maintainable in the present form, whether the post of the petitioner plaintiff allowing others who were approved by the inspector of suit on so-and-so, whether the petitioner was appointed by resolution number 2 dated so-and-so by the managing committee of Badla Rongapani as science graduate teacher, whether the name of the petitioner is entered in Dice Court as serial number 7 for the year 2012 and 13, and his senior was science teacher in Badla Rongapani High School amongst 6 science graduate teachers, whether the petitioner as well as respondent number 6 and 7 were appointed 12 9 1996, 24 1999, and 25 to 2006 respectively. Whether the petitioner has sustained any error under the new act of the Assam Education Provincialization of Service of Teachers Reorganization Act 2017, whether high schools including Badla Rongapani High School were provincialized under the guidelines of SEBA, whether respondent number 6 is adequately eligible for provincialize of his service against one post of science teacher under the provincial provision enumerated in the repealed Assam so-and-so 2011 as well as the Act of 2017. Whether the petitioner is entitled for any leave, whether the petitioner plaintiff is entitled to get decree as prayed for. These are the 10 issues which is
It's 100 of the set question. There are 26.
the decision on issue number 1 is page 100.
Yes.
So far as evidence is concerned, during the course of the proceeding, giving evidence, all the witnesses report that the petitioner respondent number 5 was the senior most. So there
But
is no-
why
no-
so many issues are framed while the direction of this court was only to determine the seniority between respondent number 5 and 6?
That's objection, because there were objections, several objections were raised by the respondent by filing a written statement. And based on that objection, perhaps because the learned court below had framed the issues.
Okay. So what is the finding on issue number 1?
Yes, sir. Let me scrutinize the available mathematical evidence on the record beside issue number 1, that as to whether the suit is maintainable in its present form. The order that it showing so far for number High Court filed by the petitioner, wherein respondent number 6, Abdul Rashid Ahmed was respondent number 5, and respondent number 7, Rahman Ali Ahmed was the respondent number 6. With the said petition was disposed of by the Honorable High Court with observation that Assam Education Provisionalization of Service Teachers and Reorganization Education Institution Act 2017, which came into force with effect from 11/4/2017 in respect of subsection 2 of section 19 provides for constitution of educational tribunal and appointed district and session judge as well as additional district and session judge of each district of Assam as chairman of the tribunal. In view of the above position, it was further observed that the petitioner is directed to approach the principal educational tribunal to determine the issue of seniority between him and the respondent number 5, that is the present respondent number 6, and respondent number 6, present respondent number 7 for provincialization of science teachers in the school in question who has already been provincialized on so and so of BSc Assam, wherein 2 posts of science teachers were yet to be provincialized. It was further observed that in the event of such prayer by the petitioner before the educational tribunal, the concerned petition shall dispose of the claim at any early date by giving opportunity of hearing of respondent number 5 and 6, as well as managing committee of the school in question, including its headmaster. As the instant petition is filed by the petitioner following the order of the so and so of the Honorable Guwahati High Court in WBC so and so, and as such, I hold that the present issue is maintainable in its present form. This issue, that is issue number 1, is decided accordingly. Now the issue number 2, the petitioner is in his petition has contended that the petitioner was appointed as science graduate teacher by the managing committee of so and so, and the managing committee in respect of appointment of teachers and other staff, including the petitioner was.
No, Mr. Das, you
Yes.
tell me, in which of the issue the learned tribunal
Yes, ma'am.
has dealt with the issue of determination of seniority between 5 and 6, respondent
Yes.
number 5 and 6.
I'll just please. Issue number 3, madam. The plaintiff petitioner has stated in his petition and also stated in his evidence as PW, that is page 102, my lord. As in his evidence as PW1, that he was appointed as science graduate teacher by the managing committee of the Badla Ramapani High School on so and so, as per the resolution of the managing committee of the said school. The resolution dated 12/9/1996 of the said school is proved as exhibit 2, which reveals that as per the resolution number 2 of the said meeting, the plaintiff petitioner was appointed as science teacher in Badla Ramapani High School. PW2 Abdul Barek Ahmed, the headmaster of the said school, has also proved the said resolution dated 12/9/1996 and has supported the contention of the petitioner. PW2 Abdul Barek Ahmed has also proved the appointment letter issued in favor of the plaintiff petitioner and the joining report of the plaintiff as exhibit 3 and exhibit 4 respectively. The defendant side has not disputed and challenged exhibit 2, 3 and 4 and the contention of the plaintiff that he has joined as science teacher in state school on 12/9/1996. DW1 Abdul Rashid Ahmed, the respondent number 6, has stated in his evidence that he was appointed as per resolution dated 26/3/1999 and joined on 24/4/1999. He has also stated that prior to his joining in the same school, plaintiff Azhar Ali Ahmed was the first science graduate teacher of the same school. He has also stated that at present also the plaintiff Azhar Ali Ahmed has been serving as science graduate teacher in the same school. Upon consideration of the above material on record, including the documentary evidence, I am of the opinion the respondent could not be able to deny and rebut the facts that Azhar Ali Ahmed was appointed as science graduate teacher by the managing committee as per resolution dated so and so. In Bodla Ramapati High School, the issue is decided accordingly in the favor of the petitioner. Then page 105.
Yes.
Hence, it is decided that the plaintiff stroke petitioner is the senior most science teacher of the Bodla Ramapani High School, among the 3 science graded teachers whose name entered in the dice code in the year 2012 and 13. In this context, the respondent number 7 duty argument has submitted that as per the SEBA regulation of the BSc teacher has to be selected, that their subject combination covers all the major branches of science and mathematics, and the respondent number 7 is a science teacher who is having physics, chemistry, and mathematics, whereas the petitioner is having mathematics, chemistry, geology, and the respondent number 6 is having mathematics and biology. Therefore, it is submitted on behalf of respondent that if the petitioner and respondent number 6 are appointed as science teachers, then who will teach physics in the school? And in view of the above position, the mere seniority cannot be a ground for provincialization. Rather, inclusion of respondent number 7 as a science teacher is not only justified but necessary for running the school, and therefore the authority has rightly included respondent number 7 and not included the petitioner who is kept excess teacher. In this context, the learned counsel for the respondent number 7 during argument relied on decision so and so, so and so, so and so. Then ultimately, my lord, page 107.
No, Mr. Das, who will teach physics? Was
That
that
is
the issue before the tribunal?
You know, they raised an issue of subject competition. That-
No, is it provided in the act?
No. In 2000. as per
In the
2000
SEBA circular, it is there.
No, SEBA circular is not.
No,
a
circular cannot override the
It's a
statutory
separate law.
provision.
It's a separate law by the Honorable Court also.
Hmm.
So subject competition was not there in 2011 Act. So subject competition can never be a criteria for provincialization. Seniority is the only criteria, and that issue has already been settled by this Honorable Court in several previous decisions. So since they have raised an issue of subject combination, because that was decided by the learned tribunal. So finally, my lord, at page 109, the order was passed in view of the decision of the issue number 1 to 10 of the suit of the plaintiff petitioner is declaring that the petitioner plaintiff Azhar Ali Ahmed is the senior most science teacher of Bodla Ramapani High School, and listing him as excess teacher is illegal. It is also revealed that the respondent number 6, Abdul Rashid Ahmed, and respondent number 7, Roham Ali Ahmed, are the second and third science teachers of Bodla Ramapani High School. The post of the suit is decreed in favor of the petitioner, and it is also decided that the respondent number 5 shall do the needful in respect of the claim of the petitioner and is declared as the senior most science teacher. So this is the declaration by the court. There is no iota of that I joined in the year 1996. The learned tribunal was to decide only the issue of seniority, and learned tribunal has decided the issue of seniority. If I am senior, and there is an affidavit filed by the headmaster saying that from 2022 onwards, he is totally absent from the school. So
No, that is a different aspect, but the question is,
don't that aspect, I am the senior most, that is established. On
no,
merit.
but the question is whether this finding, this judgment of the tribunal
Yes.
will be able to withstand the legal scrutiny or not.
My initial understanding is that, my lord, subject to what my seniors say and what falls from your lordships. Since this proceeding was initiated pursuant to a direction of this honorable court, so bar under section 19(2) would not come. That is my understanding, my lord. Till now, so I went on that pretext, my lord.
And I perhaps will have to develop an argument in that line, which except from making averments in the affidavit in opposition, no further, Milord, effort has been made on my part. Milord, I sincerely make apology for that, Milord. I should have made some effort. But
That means
I-
you want some more time.
Milord, I try to convince your lordships with in this provision of law. 19 is there, fine. It's general provision for all. But if there is a direction by the honorable court that you approach the tribunal for determination of a particular issue, whether 19 will die. And so far as the saving clause is concerned, Milord, that bar is not there. The proceedings which were pending, those will not be Milord brushed aside. 2017 saving and repeal clause, Milord, section 6 of the General Clauses Act will definitely come into play.
Here.
Okay. It will definitely come. May I just try to overcome this 91? Because I am completely of the view that since this is passed by honorable court, direction was given by this honorable court, so it will have overwhelming effect.
May not be because for instituting a civil proceeding against the government, you have to issue notice under section 80.
Correct.
But if a court,
Whether-
maybe High Court or Supreme Court directs that you go and file civil suit. But
Correct.
can you overcome that section 80? Can you ignore
Yes,
section
I'll-
80
I'll just.
CPC notice?
Yes, true, that's true. But I'll just. Here, Milord, actually, the honorable High Court relegated us. It's not, any option has been left to us that whether we'll choose the forum or, because since the.
Okay,
elevation
okay, then
tribunal was
we
wrong,
will keep the matter as part.
My lord, even if my learned friend overcomes that hurdle, my lord, now today, well, there is no recommendation in his favor. He is only senior. So there will have to be a my lord recommendation. Now, as on today, when the authority will decide, seniority is not a criteria. So I am before your lordships because the judgment is coming in the way of mine. But kindly see, let us be very pragmatic about the whole thing. My learned friend also understand. For the sake of a brief, let us not feign ignorance. Now, my lord, there was an action taken under the 2011 Act. Now, 2011 Act repeal. There is a savings clause that provincialization order passed under 2011 Act is saved with a rider that it will be examined whether such provincialization were done in consonance with the requirement of 2017 Act. Now, there is no order of provincialization either in my favor or in favor of my learned friend's client. What is there? Only thing is, my lord, this suit which has been in humble submission very irregularly decided, that will create some right in his favor. But today's seniority is not an issue. Under 2017 Act, now our cases for provincialization will have to be considered under 2017 Act. Under 2017 Act, seniority is not an issue. It has to be decided on its own merit. But if the judgment stays, my lord, then my right would be prejudiced. That's why I've challenged it. Otherwise, my lord, that's why my learned friend says, I'm not interested. That is, it's not a question of I being not interested. What is the consequence in law? That is what I have said. Let my learned friend address your lordships on that point. That's a different issue, my lord. But end of the result, that will happen. Because today's seniority is not a relevant issue. Because earlier law is not there. When a statute is repealed, the implication is as if it never stood. Yes, if the repealing statute wants to save some action, it can do. Now, section 6 of the General Clauses Act will not come into play because partly section General 6 will not come into play, my lord. There is already a savings clause. Savings clause saves only a part of the action. This action of my learned friend's client, which is in his favor, that has not been saved. So it makes no sense. But if the judgment stands as it stands today, my lord, then it will prejudice my case. That's why, my lord. And then my learned friend can argue on that point, my lord.
I have not had any litigation or any, I have not gone before a panel also. So I should not suffer also under this, I am in middle party.
Okay, we'll fix a very short date.
Yes.
My
Okay.
come under that.
Okay.
And also I have already
Okay, wait for one date only.
Yes.
Director will adjudicate the matter.
Lord, there is a judgment of our High Court which says the subject combination will not do. That was in the context of 2011 Act, and there is a new case is there. But in the new scheme of things, that is not even relevant, my lord. Now, my lord, even if your lordship dismisses my writ petition, his right will not revive.
That I will satisfy. That I will satisfy.
How can you satisfy? So there has to be a savings clause. Where is that savings clause?
My learned senior may be true.
No, Mr. Das,
Yes, sir.
now your case, even if we allow the
Yes.
petition, then your case has to be considered.
Under the 17 Act.
17 Act.
No, my lord. No, in my
Why?
respectful submission, my lord, my case will come under the
Repeal Act.
2011, because this
No.
entire thing, lord, if this interpretation as has been presented by senior is given, my lord, then the entire meaning.
No,
will go,
this
my
is
lord.
happening, Mr. Das, you see, some of the writ petitions are allowed
Yes,
to consider the case of the petitioners under the 2011 Act.
yes, there has to be,
No, allowed.
yes.
But now government has filed a review petition that since the act has been repealed, we cannot implement this order.
Milord, my learned friend may not be aware of, there is a series of division bench judgment of our High Court where the vested and accrued right point I argued, Milord, it was rejected. That I have a vested right, accrued right under 2011 Act. It so happened, Milord, cases of some teachers were considered. Our cases were left to be considered at a later date. In the meantime, Act was struck down. Then, Milord, 2017 Act came. We said our cases were considered, our brethren were given appointment. Now it is our turn, consider our case under 2011 Act. Court says nothing doing, dismiss. Division bench, Milord, series of cases. Honorable Justice Shuman Sham and Honorable Justice Milord or Arnab Chaudhary. Like division bench was constituted to deal with these education matters, where court has not recognized any right qua the 2011 Act.
So those cases, actually,
Same thing, Baba.
those cases are subject to what my senior, subject to correction of my senior, those cases were actually different. Year 2000,
Even there also there were
prior,
judgments.
2003, Milord, the cases were provincialized, everything, only two left because of the litigation. I'll try to convict, Milord. I'll try to
Okay,
convict.
okay.
Also, in the 2017 Provincial Act taken into constitution, then also we are entitled as tutor also. Only the nomenclature will be also, if in terms of 2011, we will be assistant teacher, in terms of 2017 Act also we will be tutor.
Okay.
Only the sense of nomenclature.
Okay. Heard Mr. Ken Soduri, learned senior counsel assisted by Mr. Kelly, learned counsel for the petitioner. In WPC number
Our number to
4387.
4387.
4387. 4387. And also heard Mr. S. Das, learned counsel for the respondent number 6, and Mr. Das for respondent
Respondent
number
five.
5. Heard in part, list the matter on 18/12.
18, I'm not there, Milord.
When? Suggested that then,
Whether after the vacation or before the vacation, Milord.
before vacation,
16.
6 book.